Okay, so we're here to talk about local authority, and as Carl said, we do get a lot of calls. Oh, sorry, I'm Rebecca Craven. I'm the program director for the Pipeline Safety Trust. We do get a lot of calls from around the country, from local governments and concerned community members who have been to local government meetings where they've been met by groups of operators or operator representatives who strongly tried to dissuade them from enacting any new local regulation. And the conversations that occur at those meetings are perceived as slightly threatening to local governments without the means to defend themselves against a legal challenge should they decide to go ahead and regulate and subsequently be challenged by the operator. So we put this panel together to talk about the variety of choices that local governments have in participation in various aspects of regulation and also within the FERC process and other siting processes that are going on at various state levels. So before I start, there are 3 lawyers up here. We will try to keep our Exactly. We will try to stay on time, and we will leave time for questions at the end. But also, because there are 3 lawyers up here, one of whom is not licensed in Washington anyway, I'm not intending to give anybody legal advice. If you're a local government and you intend to enact regulation, I strongly encourage you to obtain local counsel to get advice as to the application of particular state laws. We're going to skim across the top of a lot of fairly complicated issues, and so be forewarned that this is not something that you should take to the bank. So for local governments facing new pipeline being proposed or reaching new agreements with existing pipelines for crossing local government roads or other utility rights of way, the extent of their authorities is sometimes uncertain or sometimes made to seem uncertain, even if it may not be. For operators, there's uncertainty in the potential changes in local government laws if a local government were to enact regulations that then make the legal landscape different than when you originally planned a particular pipeline. So my apologies, but we're going to have a little civics lesson here. In order to understand what is preempted by federal government and what is not, you need to understand the source of the preemption doctrine, which does come from the Constitution, the Supremacy Clause, which I've included up there, which you don't need to read, but it essentially says where a state law is in conflict with a federal law, the federal law is going to be supreme. In the pipeline world, the preemption types that come into play are a couple. There's express preemption in a situation where Congress says the federal government's going to regulate this and the states can't regulate. An example of that is in 49 U.S.C. 60104, which it says that the state authority can't adopt or continue enforce safety standards for interstate pipelines or pipeline transportation. There are 2 kinds of implied preemption where Congress is less explicit about its intent. One of those is where a set of federal laws would come into conflict with a separate set of state laws. A situation like the Natural Gas Act, Section 7, which gives FERC jurisdiction over the siting and routing of interstate gas lines. It would be difficult to have a state set of routing laws that would not be in conflict with that. So that would be an example of conflict preemption. On the other hand, there are situations where Congress, either implicitly or expressly, has not preempted state law. For example, under the same section but a different subsection, PHMSA is expressly not granted authority to regulate siting. And so the routing and location of pipelines other than interstate natural gas lines is an area that is open to state and local regulation. And in fact, there are a number of states that have enacted siting and routing laws to govern those. Separately, Congress can explicitly say that state and local authority has been preserved, and that an example of that is in OPA 1990, which is the amendment to the Clean Water Act that was passed after the Exxon Valdez spill. And Congress in that statute explicitly said that state and local authority is preserved over planning, liability, and cleanup aspects. So there is an opportunity, which not very many states have taken advantage of, to enact spill planning requirements and cleanup requirements. So where's the confusion? If some things are exempted and some things are preempted and some things aren't, why is there any confusion? Well, part of it is because the language in the statute. Defining what a safety statute is that's preempted under the PHMSA statutes is less than clear. For example, is a setback enacted for any reason a safety standard? Well, what if it's a setback for aesthetic purposes, or what if it's a setback for protection of another land use that's on the adjoining property? There are examples of cases upholding setbacks, and the Fifth Circuit case in Texas explicitly upholds a setback that was enacted by a local government against a challenge by the operator. Similarly, zoning requirements, which cover a lot of ground, they're typically allowable uses within a particular zone. Again, a zoning requirement for, well, denying a permit for the construction of an LNG facility in Maryland was upheld. So that's confusing. The court said it was okay for the local government to deny permission to build the LNG facility because they had in place existing zoning that was intended to designate that area for transit-oriented development and open space, and the court upheld that local jurisdiction's authority to do that. Again, there's another, a whole series of examples, and each of these will need to go through a preemption analysis to determine congressional intent, the intent of the local government, and the effect of the particular effort on the part of the local government. For example, in Washington, local governments need to have critical areas ordinances that provide buffers around steep slopes. Well, okay, does a critical areas ordinance that does provide that buffer, is that preempted by PHMSA's requirement that operators consider unstable slopes in their integrity management plans? There are going to be situations where there is uncertainty and there needs to be a way to resolve that. The situation that I think is going to be most interesting is siting rules that are actually motivated by safety concerns. The Fifth Circuit case in Texas upholding a setback upheld a setback that was pretty clearly not intended originally as a safety standard. It was established for other reasons. The question's then going to come up. In a situation where a local government does establish a setback specifically for a safety purpose, whether or not that's a safety standard. So the PHMSA statute, as you know, prohibits PHMSA from undertaking location and routing of pipelines. If it's determined that local governments are preempted from enacting siting and routing based on safety concerns, that leads to the conclusion that then no government is able to enact routing rules that are based on safety. And I find that a fairly counterintuitive conclusion to come to, and I think it would be a difficult argument to make to a court that that was Congress's intent, that there was that there should be no government that could cite based on safety concerns. But that's a case that's out there still, and it hasn't happened yet. There's another aspect of this that I think Carolyn's going to talk to, and that's what happens when a federal law meets a federal law. There are situations under the Clean Air Act and the Coastal Zone Management Act where implementation of those federal statutes is based on state-approved implementation plans. So if you have a state implementation plan for a federal statute that then perhaps conflicts with another federal statute, the FERC statutes in particular, there comes a conflict that's determined under slightly different rules, and I think Carolyn's going to talk about that. So we're back to the uncertainty and the need, I think, to establish a new model. Excuse me. For a couple of reasons. Pipeline construction is continuing. Local governments do have legitimate concerns, both financial, excuse me, and environmental and public safety, and limitations on future development, as was the case in the Maryland case. So with the understanding that there is, for the time being at least, a continuing need for siting of new pipelines, there needs to be a way to have less uncertainty on both sides. Litigation is one way to do that, but it's expensive. It, unfortunately, from the local government's perspective, pretty typically favors those with deep pockets and a fair amount of time, because most local governments don't have the capacity to undertake defense of a lawsuit if they're challenged. Another possibility, at least for zoning questions, is raised by the situation in Adams County, Colorado. They made news a few weeks ago because their county commission denied a conditional use permit for the location of a natural gas line going through there. And we hadn't heard about their conditional use setup and got some information from their planning department. They've taken the tack that any new pipeline coming through the county is treated as a conditional use. So it goes through their normal conditional use application process. The operators seem to be perfectly willing to bring their applications. They go through an alternatives analysis. They work with the planning commission, and it's at least thus far, a pretty functional model for getting these zoning issues resolved. After the county commission denied the conditional use permit, they asked the operator to bring back an amended application, and that's underway. So it was not a situation where the county was trying to stop the pipeline. They simply wanted it moved to a different place. So for other aspects of pipeline regulation, I'm just going to leave you with a question, and that is, what degree of certainty does the industry need to discontinue the current model of discourse between local governments and the industry? It seems to me that it's going to become a continuing problem, and relying on litigation to determine each particular local government law case by case is not a particularly efficient or healthy way to go about resolving that. So with that, I'm going to turn it over to Carolyn.